This is another lecture about conflicts of interest for my professional responsibility course. And in this lecture, we're going to proceed and start going through some of the ABA's official comments to the conflicts of interest rules, and the main rule, which is 1.7. Now, the big takeaway from this video. So if you want to know what you're supposed to get out of this right up front, it's what are you supposed to do about a conflict of interest? And the model rules that comment 1 is sort of just this restating the rule a little bit. Conflicts are bad. And comment 2 says, here's the actions required of lawyers. Resolution of a conflict of interest problem under this rule requires the lawyer to do the following. This is a really useful slide or comment 2, to study early on while you're learning this rule for purposes of test questions and multiple choice questions, because this gives you the actual action items for the lawyer, or the specific duties for which a lawyer could be disciplined if they don't do this, if they fail to carry these things out. So first of all, the first step is you have to clearly identify who is your client, and or who are the clients. And this sounds easy, like, well, the client's anybody I agree to represent, but it can actually get kind of confusing, because there's people that may come in for a consultation, and you tell them you'll get back to them or decide whether to represent them, and you do a little work on the case and get a little more information, then you decide not to proceed with the representation. And the question is, were they a client? You also have people who are going to corner you in a social situation at a wedding. They sit next to you at the wedding reception, and they say, hey, you're a lawyer, can I ask you for some legal advice? And you go ahead and volunteer some legal advice to them, listen to their situation, tell them, oh, by the way, totally don't sign that, or you should sue that person, or something like that. You may not think that you've agreed to represent them, but it may have been reasonable, we may say in hindsight, for a non-lawyer layperson to feel like it was reasonable to think that you were giving them legal advice or legal representation. On and on. This can get very complicated. You're in-house counsel at a corporation, and you're sitting in a meeting, and they're not asking you for legal advice, you think, but they're proposing a new marketing strategy, and you tell them why you think that's a bad idea, or why you think they should switch vendors, or consider opening a new distribution line or something like that, and switch trucking companies. And it's a question of what part of this is legal advice and what part is business advice. So it can be a little confusing. And then to give one more quick scenario, I want you to think about the situation where you have someone who is being sued over a traffic accident, a fender bender, and their liability insurer has taken over the case. And what they're going to do is they're going to go and hire a lawyer to represent their policyholder. So the question is, who's your client? Is the insurance company your client? We know that for sure, the model rules say the policyholder is, but there's some uncertainty, and the ABA hasn't answered the question, actually, but whether the insurer, who's the one paying your bills, might also be a client in that situation. So the policyholder, you've been hired to represent them in the accident, so there's no question that they're a client. And the confusion can be about the person who's hired you to represent someone else. Okay, secondly, then you have to determine whether a conflict of interest exists. And now that may be pretty easy, but I hope you can see that we're going to have a little bit of gray area or blurry lines around the edges. And so sometimes in class, I can give clear situations. This is part of the difficulty of reading cases about conflicts of interest, because the ones where the court is issuing an opinion, the court is going to frame it as obviously there's a conflict here. But in day-to-day practice as a lawyer, you have a lot of judgment calls to make where you're thinking, okay, I can conceive of some disagreements or different opinions between these two clients of mine, or some adversity, or I like one more than the other, or something like that. And or you're representing co-defendants or something, and one of them you find really charming and you get along with, and the other you think is you find difficult to relate to. And so the question is that so attenuated it's not really a conflict, or is it a conflict? And then 3, decide whether the representation could be undertaken anyways, despite the existence of a conflict, whether the conflict is consentable. And so I'm going to give you a really easy scenario. You have a husband and wife, let's say, and I'm going to come back to this several times during the conflicts of interest section. The middle-aged husband and wife who come to a lawyer saying, we want to draft a will. And let's say they're middle-aged and middle class. And so you have a middle class, middle-aged husband and wife. They probably have one big asset, which is their home. They may own a couple of cars, but they're used cars and aren't actually all that valuable. And they have some retirement savings and stuff like that. And these types of wills are everyday things. We're not talking about big, complicated estates for millionaires. We're talking about people who own a home in the suburbs that's worth a couple $100,000 and that they still owe some money on. And what do they want to do? Very typical. They say, well, if anything happens to me, I want to leave everything to my spouse. If anything happens to my spouse, everything gets left to me. If something happens to both of us, it all goes to our kids, or if we don't have kids, to our favorite charity, our favorite nieces and nephews, or something like that. And so that may seem to you as a lawyer, okay, no conflicts, but conflicts can arise, right? So what if they actually have marriage problems and they're thinking of breaking up? What if one of them has children from an affair that they've never told their spouse about, and something that could really affect the inheritance rights under this will you're drafting? On and on and on. So there's all sorts of things that potentially, they're unlikely, those are rare scenarios, right, where somebody has a child that they've out there that they've never told their spouse about. But trust me, stranger things have happened. And the or after they draft the will, they split up. All sorts of things can happen that can create ambiguity. So you have to decide, is a conflict too attenuated, or if it seems like it's a remote chance what we're talking about, could I go ahead and represent them? And so are these is this two friends, two of your clients who are friends, and one wants to sell the other their boat, let's say, and they've already agreed on a price, they just need you to draft the document? Well, there's potentially a conflict, but could you probably do it with informed consent from both of them? Sure, right? There's nothing to dispute. Could you have two litigants come to you who have already settled a claim, they've already litigated a claim, and now they want to, I don't know, create an amendment to or some sort of modification or something like that? Possibly. And so, all right. And then 4, if there is a conflict, but it's so minor or attenuated that you think you could still provide adequate representation anyways, then you consult with the clients affected under the paragraph and obtain informed consent from both of them and get it in writing. And so here's our steps. Identify the client, determine whether there's a conflict, decide, is this a conflict where I really can't represent both of these people, or is this a minor conflict where I could do this anyways? I'll give you another quick scenario. You have 4 friends who went out, teenagers, and they went out on their prom night and were driving around town with a lot of alcohol in the car and so forth, and they get arrested, and the police charge all of them with minor in possession charges. And so they all come to you and want you to be their lawyer, and the DA has already agreed that they're all getting deferred adjudication, right? Like, you know the DA and you know what's going to happen. And so you know they're going to get a deferred adjudication. It's a first charge and it's minor in possession for them. And so could you probably represent that group? Sure, sure. It's not you already know it's probably not going to go, it's very unlikely to go to trial. We're not going to have people potentially being offered deals to testify against each other. There's no real reason for them to file cross claims against each other. And so, but you're still going to need to get informed consent confirmed in writing. a conflict of interest may exist before the representation is undertaken. If so, normally the representation should be declined. And so this, we can almost add this like to the previous slide. This is comment 3. But if someone comes in, Greenacre comes into your office and they say, I need to sue somebody, I heard they smashed my car, and you say, great, who do you want to sue? And they say, Redacre, and you're like, oh, I already represent Redacre on another matter, you need to send Greenacre away, right? You don't agree to represent them. So the default position is don't represent somebody when there's a conflict. Unless you think that the Redacre who you already represent is going to say, sure, represent Greenacre, what do I care? At least I know you, or something like that. Could happen. So normally we're going to decline the representation if you can tell up front that there's a conflict of interest. Now, here's another duty that you need to have, and this is a testable action item. In other words, could the lawyer be subject to discipline for not doing this? Yes. So to determine whether conflict of interest exists, a lawyer should adopt reasonable procedures appropriate for the size and type of the firm in practice to determine in both litigation and non-litigation, in other words, transactional matters, the person and issues involved. What are we saying? It's not enough to say you don't represent people who have a conflict of interest. Don't be that guy. Don't be that lawyer. But you have an ethical duty to screen for conflicts. I'm going to say that again. You have an ethical duty that you can be subject to discipline for neglecting, and that duty is to screen for conflicts up front. Now, if you're the Lincoln lawyer and you're representing people out of the back of your car or your parents' basement, and you can count all of your clients on your fingers, conflict screening is very easy, right? Someone calls you and says, I need you to represent me. And you say, great, who's the other party? And they tell you, and you can just think, oh, okay, I've never heard of them. I guess I can do it. Maybe that's all right. And if you are a small-time lawyer with a handful of clients, screening is easy. On the other hand, if you work for a big national or international firm that employs hundreds or even thousands of lawyers who all represent dozens of clients, and some of these are complicated corporate conglomerates that own dozens of subsidiaries and have joint ventures with other corporations and so forth, conflicts analysis gets very complicated. So what's an appropriate procedure there? Big firms are going to have special software. There's products that you can buy to help analyze and screen for conflicts, and they're not cheap. As you can imagine, if a company makes software for big law firms, it's not going to be cheap. And then we may even have some support staff. Either all the support staff are going to be trained in conflict screening, or you're going to have a few devoted support staff that's a big part of their whole job is to spend all day, every day trying to look at prospective clients that are coming into the firm and analyze whether there's conflicts with the other thousands and thousands of entities and individuals that this firm has represented. So basically, as you have more lawyers and more offices and more clients, the number of potential conflicts goes up exponentially. Now, sometimes a conflict is going to arise after the representation is undertaken. And in that case, you may have to withdraw. So you represented two people and it didn't seem like there was any disagreement between them at all. And you had two family members or a husband and wife who wanted to buy a home together or something like that and have it be in both of their names, like joint ownership or co-tenancy. And then all of a sudden they're fighting about it. Or it could be that you represent Greenacre and Redacre, and then, but it turns out that Greenacre buys a subsidiary that is in the process of suing Redacre. And so corporate realignments can cause conflicts to arise that were unforeseeable because they hadn't arisen yet when you undertook the representation, and that may necessitate withdrawing. Now, if you have more than one client involved, sometimes you're going to be able to continue representing one of them and just withdraw from representing the other. you should be aware you may be forced to withdraw from both. And so this is one of our first reasons, apart from getting in trouble with the bar, apart from malpractice actions, apart from something called disqualification we'll talk about later. I want you to think about the consequences for you as an associate at the firm. If you decide that you're going to take some risks with conflicts of interest, you could put your firm in a situation where suddenly it has to withdraw from representing multiple very lucrative clients. And that's can be a huge financial setback for a firm to lose business and billable hours that they were counting on in the coming months. And so this hurts, and it's really worth thinking about it up front. Okay, and that's it for this presentation about conflicts of interest, and we'll continue in a subsequent video.